All right, glad to see we have everyone in the panel present. Apologies for the slight delay. Dear audience members, members of the EPC, and everyone joining us online from Brussels and beyond, a very warm welcome to today's policy dialogue on the outlook on the EU's approach to return. My name is Helena Hahn, and on behalf of the European Policy Center and the Egmont Institute, I have the pleasure of providing some opening remarks ahead of today's event. The EPC and Egmont Institute have long collaborated around our respective work on EU migration and asylum policies with the aim of facilitating dialogue between a wide range of stakeholders on priority topics at EU and national levels. We did so in the context of the negotiations of the new Pact on Migration and Asylum, with our most recent event that some of you may have attended happening at a time when the likelihood of the reforms being adopted before the EU elections began to crystallize. Now, about a year later, we find ourselves in the early stages of a new legislative cycle with the new European Commission in office and a rapidly changing political environment. It is against this background that we're very pleased to offer an opportunity to discuss the Commission's latest initiative in the migration portfolio, the proposed return regulation, and some of the key questions surrounding it. As most of you will be aware, the tabling of this proposal follows a long road of policy development in the field of return. The 2008 directive, which this regulation proposes to replace, is a comparatively short piece of legislation that has acted as the main framework for member states until now. However, even while the policy landscape changed considerably, as did migratory patterns and political trends, the latest attempt to reform legislation in 2018 did not succeed. A combination of political exigency and new political realities led Commission President Ursula von der Leyen to make return a key priority for her second mandate, also reflecting demands by several member states calling for a new approach to returns. Against this background, today's event will be divided into two panels. The first panel aims at unpacking the proposal, delving into some of the key elements of an effective and common EU return system, its role vis-a-vis the new pact, and questions around its political feasibility in light of past experiences negotiating the file and the impending talks between the co-legislators. The second panel, conversely, will build on this discussion by examining more closely questions around the proposal's ability to bridge gaps in the current system, as well as questions on the implementation of key provisions and their impact on fundamental rights. After an exchange with the panelists, there will be a Q&A. Given the division of topics between the two panels, I would kindly ask questions around implementation and coordination in particular to be left to the second panel. The panels will be moderated by Jean-Louis de Brouwer to my right, who is Director of the European Affairs Program at the Egmont Institute, as well as Alberto Neidhardt, who is Senior Policy Analyst and Head of Program of the European Migration and Diversity Program here at the European Policy Center. Before handing over to the moderators of the two sessions, who will explore the aforementioned questions as well as further ones with an excellent set of speakers, I'm pleased to kick off the event with an opening statement from the European Commissioner for Migration and Internal Affairs, Magnus Brunner. He unfortunately could not be here in person due to planned travels, but has kindly offered to share some of his reflections by video.
Good afternoon, ladies and gentlemen. I want to thank the European Policy Center as well as the Egmont Institute for organizing organizing this important event today. I'm sure that the colleagues who are from DG Home will explain the Commission's perspective on the proposal much better than I could. Together with members, we are advancing work and asylum agreed last year. However, there is one key missing piece of the puzzle. It is the element of returns. The truth is that the proposal was long overdue. The previous rules on returns were designed in the early 2000s, and the recast from 2018 stalled. This had the effect that we reached a point, the ineffectiveness of our return system risked undermining credibility.
Apologies, it seems we've encountered some technical difficulties. We're just seeing if we can maybe restart the video so that there's no lapses in the audio. So if you could just bear with us for a minute.
Good afternoon, ladies and gentlemen. I want to thank the European Policy Center as well as the Egmont Institute for organizing this important event today. I'm sorry I can't be with you in person, but I'm sure that the colleagues who are with you from DG Home will explain the Commission's perspective on the proposal much better than I could. Together with member states, we are advancing the work on the Pact on Migration and Asylum agreed last year. However, there is one key missing piece of the puzzle. It is the element of returns. The truth is that the proposal was long overdue. The previous rules on returns were designed in the early 2000s, and the recast from 2018 stalled in the European Parliament. This had the effect that we reached a point, the ineffectiveness of our return system risked undermining the credibility of our entire migration system and the proper functioning of the Schengen area. Only 1 in 5 people that have a return decision are actually returned. We have 27 different systems, and people with a return decision flee from one member state to the next without facing consequences. This is unacceptable. This blocks resources that are badly needed for the processing of asylum requests and for the integration of those who do have a right to stay. And it takes away from our ability to fulfill our obligations under international law. That is why we have opted for a new approach, one that creates a truly European system for returns. It is a system that is fair in the sense that it fully respects fundamental rights. After all, that is non-negotiable. But the proposed system is also firm. It comes as a regulation because we need to end the fragmentation of national systems. It sets out new obligations on returnees, especially those who pose a security risk. It also sets out minimum legal conditions for member states to explore innovative solutions like return hubs. My point is this: we are putting our house in order, everything that can be done on our side to make sure that when someone is told to leave the European Union, they actually leave the European Union. I also want to stress that this proposal can only address one side of the coin. A return decision means nothing without readmission in a third country. And that is why, in parallel to the internal work covered by this proposal, my colleagues and I will be stepping up our efforts on migration diplomacy. That means improving our dialogue with third countries. It also means including the discussion on returns and readmission in all our dealings with third countries, for example, in trade and investment, in capacity building, or in visa dialogues. The proposal is now with the European Parliament and with the Council. Our initial exchanges have been quite positive. However, I want to stress a sense of urgency. For our part, the Commission will do everything we can to maintain that forward momentum. Time is of the essence. Thank you very much.
And with that, given that time is indeed of the essence, I would like to hand over to the moderator of the first panel, which is entitled Unpacking the Commission's Proposal, Priorities and Next Steps. Jean-Louis, the floor is yours.
Thank you very much, Helena, and thank you for introducing us and introducing the panel. And I will start by where I would end in principle, that's to say thanking the EPC and the Egmont team for the fantastic cooperation in preparing that event. Very much appreciated from all sides. So let's then go, let's start now with this first panel. Johannes Luchner, Johannes, I know how difficult, let alone dangerous, it can be for a senior official to take the floor immediately following his commissioner, but yet the first question will be for you. The commissioner said it all. I mean, this new approach to return is, I mean, a major piece of the Migration Pact jigsaw. The Commission and the Member States are now in full swing implementing the pact. But these proposals comes now, that's to say more or less 1 year after the formal agreement on the pact. And still it will be followed by other initiatives which were announced and confirmed recently by the President of the Commission, the digital proposal during the second semester of this year, and the revision of Frontex mandate, well, Frontex, I still use the same logo, the same old logo, in the beginning of next year. So my question to you, and it relates to the time of the essence of the Commissioner, is how will the Commission make sure that at the end all pieces of the jigsaws fall into place in a coordinated way? Over to you.
Thank you very much. That's not a question I had. Look, thanks first to you, Jean-Louis, to the Egmont Institute, to EPC for inviting us. This indeed is part and parcel of the pact. The proposal was written by the same group of people who wrote the pact, so it is perfectly coherent. We do have, however, clearly a capacity issue on all sides, I would say, except the European Parliament. The pact, as you know, is more than 300 pages of legal text. The implementation requires, in some member states, very, very substantive structural and legal changes that don't come overnight. It creates new permanent institutions when you think about monitoring, for instance, and quite a number of new obligations member states have to fulfill. Now, one indication that this regulation, this proposal for a regulation aligns with the pact is the fact that it's no longer a directive, but a regulation. Now, this is largely due to the content, but it is also due to the fact that time now is of the essence. And of course, ideally, this should be in place and it should be law by 2026, when the pact will need to be fully implemented. Now, having worked with my colleague, Mari Juritsch, the return coordinator, for a number of years, I want to just set out some of the essentials. The pact will not work without this, because one of the key elements of the pact is the so-called border procedure, which allows you to have an accelerated procedure for those nationalities whose asylum recognition rate is below 20%. In other words, where the probability that they will get asylum is structurally lower. Now, if they don't, then of course you need to return them. In other words, this first part hinges upon return. And as the Commissioner has said, right now, we're at plus minus 20% of successful returns of people who have a return order. However, in addition to that, we also have a huge gap between return orders issued and actual returns, which is sort of 500,000 return orders and then 100,000 requests for actual returns. So we also have serious internal issues, and most of this regulation is on the internal issues. Therefore, what we want to do, and Mary will elaborate more in detail from her operational experience, is to make things simpler and more efficient, while fully respecting fundamental rights, in particular, but not only, but in particular of those who are particularly vulnerable. As you have seen in the regulation, there's a specific chapter on minors, on unaccompanied minors, to make sure the safeguards are in place. Some people in member states have told us, but now you're becoming very tough on forced returns, and this is all about forced returns. And others have said, this is not really any strengthening of forced returns. It's still all about voluntary returns. It's about both. On the question of removal, as the regulation calls it, on forced returns, one key aspect that we focused on very much is people who pose a security threat. And that is, of course, due to the fact that we have had a number of attacks, a number of murders in public places over the last couple of years, of people who had a return decision, but who were never returned. So we want to make sure that we have a specific categorization there with specific rules that allow member states to protect the safety of citizens. We also have new obligations in this regulation, in particular when it comes to counseling for returns. Some of the things that you would need to do, and you would imagine that they happen anyways, are relatively banal, but they don't happen across the board, which is, for instance, counseling of returnee candidates, explaining to them what the options are, explaining to them why a voluntary return is a much better option than a forced return, explaining to them that there is reintegration assistance, which very often they just don't know what would happen to them if they return. So to make sure that there's an obligation actually on our EU authorities in member states to explain these things. Then there is a certain degree of harmonization. There's a European return order. Why that? Well, if you look at the reality, very often the paper a returnee gets, the decision is to leave the country's territory, the country in which he is. Schengen isn't mentioned, the European Union isn't mentioned, but of course a return order is a return order to leave the Schengen area. So we believe we should say that. We should also harmonize what is in the order and therefore create a European return order. Why do we need to harmonize it? Because we want member states to be able to recognize each other's return decisions. So somebody has a return decision in France, who appears then in Germany, that return Germany should be able to organize rather than trying to send the person back or starting a whole new procedure from scratch. Now, the one part I'm particularly happy about is the readmission part. This is a first. We never had readmission in any of the return legislation. And again, there are some technical things in there which in practical life, when you negotiate with third countries, appear. One is, if I go and negotiate with authorities whose government is not recognized as legitimate by the European Union, but I have, for instance, criminals to return who have done their sentence, and either I return them or I let them go with the risk that they will become repeat offenders, what do I do? So we say clearly in the proposal now, negotiations at technical level with third countries in no way imply recognition of the authorities' legitimacy. Another part is the transfer of information on criminals. Now, if you returns a criminal to a third country, I think it is perfectly understandable and legitimate that the authorities tell you, I need to know why the person went to jail in the first place. in particular if it's a terrorist, but also if it's a regular criminal. We have no legal basis in the European Union for that for the moment, which means some member states make this information even public, whereas other member states have data protection rules that forbid them to share this information. And again, we're talking about the Schengen area, one zone where the same rules should apply. So we also have introduced that and a few other things we need to make negotiations more successful. When it comes to minors, again, there are specific protections in there, and there is also parallelism to the rest of the pact, for instance, when it comes to the assessment of minors. But also once you have assessed that a migrant or an asylum seeker is indeed a minor, or a person that needs to be returned is a minor, that person has an obligatory counselor and somebody who represents them, but somebody who has also the corresponding training to represent them. Just one word on the IT system. Those are always very complex operations, and it was not possible for us within 3 months to work on that and come up with solutions. What we would want is a case management system. That sounds simple, but we have member states where the list of returnees are being sent around with Excel tables, by email. And I'm not talking about the poorest member states here. So we want the case management system. The irony is that we have created that with EU funding for third countries. We have quite a few third countries now who have an IT case management system for returns, but we don't have it ourselves. So we want to also set that up, and we hope that in the autumn later this year, we will be able to make proposals to indeed have the system completed. Thanks.
Thank you, Johannes. You are again clearly illustrated how indispensable this instrument will be to facilitate and to make possible the implementation of the pact. So the Commission has done its homework, but the ball is now clearly in the court of the co-legislator. Lena Düpont, I mean, you were, to my knowledge, one of the first members of the European Parliament going public on this new approach of return. And you expressed kind of an initial, very positive approach of the proposal tabled by the Commission. Now, we all know, of course, that the previous endeavor to recast the return directive did not come to fruition because there was disagreement inside the European Parliament. What makes you think that maybe this proposal could be somewhat more easily palatable by inside the European Parliament? Is it susceptible to help those supporting the proposal to reach more quickly an agreement with the other political groups, or do you foresee similar difficulties?
Well, maybe also sharing a bit, also some reflections on what we have been doing in the previous term, and answering your question whether it's now easier or not. Very openly here with you, I think it's not yet said and done. I could easily say, well, it's a good proposal, like you just mentioned. It's a proposal that specifically also the EPP not only welcomes, but really also in terms of balancing rights and safeguards, and also the requests for cooperation from returnees. It's actually more in a balance than what we had seen before. This is an initial EPP reaction also to that. Coming a bit back from one of the probably most repeated sentence that I had also been constantly saying during the negotiations, for example, on APR, is that we put a lot of focus, for various good reasons, on the effectiveness of procedures. Mm-hmm. Because we see, like it was just mentioned, that there is a huge gap between actually the decision taken and the return being put into practice in reality. And there's a huge room for improvement. And effectiveness is not a cause in itself, not because I specifically like effective procedures, but it actually helps fulfilling what we had put into law. The one hand, granting protection to those who are in need of protection, but at the same time also be, and this is the fair part, mm-hmm. but also be firm with those who don't have the right, at least not on the basis of international protection, to be in the European Union. And in that extent, it's a logical follow-up on what we had actually also been doing in the previous term. But the effectiveness, by the same way, applies in strengthening the safeguards, because by applying them in the same way in all 27 member states, it actually strengthened the safeguards. Plus, on top of that, of those who are in the paper who hadn't been there before. So I think that this is actually something that could potentially help the negotiations in the parliament. Just a short reminder, it was indeed stalled in parliament, but it was also stalled in parliament because council had already on various occasions made clear that on basis of that proposal, they were never ever start the discussion. So this is also something that had changed now. At least there's a bit of a fresh start, I would say. And coming again back from the work on the pact, it is indeed not only the last missing piece, but also here again, and this is something we had been discussing also in the previous term, just because we have now returns on the table does not mean that the European Union is only discussing about returns. We still have open proposals when it comes to legal migration, the talent pool, the talent partnerships. Whatever we do in third country cooperation is still ongoing. We have the facilitators package still on. So there's a lot of initiatives around the return proposal as such that actually feed into the asylum and migration policy at the European Union. But of course, since it is now the newest proposal on the table and the first concrete legislative proposal in this term, of course, there's a lot of focus on that. So indeed, to sum up, I think there's a specific logic in the pact that is, I would say, easier to swallow for also the rest of the parliament. And then, of course, now it's up to the negotiations between the groups on how the proposal will look like in the end.
Thank you very much. Thank you very much. Before turning to the other branch of the legislature, a quick word as a moderator. So we have a virtual and a physical audience. Within 10 to 15 minutes, we'll start a Q&A session. And I would encourage those following us online to maybe already start asking questions and using the chat box for that purpose. It's not always very easy to manage a Q&A session when you have an hybrid audience. So I would really encourage those following us online not to wait until the end of the conversation between the panelists to start posting questions in the chat box. Now, turning to the presidency. Eva, it is indeed a regulation, which is a major difference with regard to the previous proposal, which was a directive. Well, my instinct is that it might be somewhat more difficult to lead a negotiation on the draft regulation than on the draft directive, because, of course, I mean, the very purpose of the draft directive is to allow what we call usually amongst official constructive ambiguity. That's to say, you know, that kind of very fluffy legal text that will, at the end of the day, leave all the member states the freedom they need for the implementation, which was apparently one of the flaws of the previous directive. Now you have to negotiate on a regulation. And we know also that when it comes to the regulation, even though there is strong political backing from the political masters, we read the conclusion of the last European Council, national bureaucracies might be on the brakes and say, oh my goodness, I mean, this will impose on me a supplementing bureaucracy burden, and therefore be less inclined to embrace enthusiastically the proposal tabled by the Commission. How do you see that from the presidency point of view?
Good afternoon, ladies and gentlemen. Thank you very much for the invitation. It's a pleasure to be here today and to work on this new proposal. Work on the improvement of effectiveness of the return are the key priority for Polish presidency, as probably everybody know. So in our view, efficiency in this area is a key pillar of credible migration policy. But on the other hand, current legal framework for return is outdated and no longer responds to current needs of member states. As you said, updating this proposal was on the agenda from, let's say, 2018, when the proposal for recast was made by the Commission. And as well, the 2024 evaluation, Schengen evaluation on return and has indicated that many member states had not transported or not sufficiently transposed certain provisions from the directive. It shows that different approaches have an impact on the effectiveness of the return system. A regulation, which is the form which was chosen by the Commission, once we enforce, will be directly applicable in all the EU as a binding legal act. The introduction of such form of proposal implies a reduction in current flexibility, which, as I said, may be not very welcome by some member states. May increase, of course, also costs of implementation on the side of member states. On the other hand, we are all aware that the current flexibility does not give us a tool to ensure the effectiveness of returns. It's obvious, I think. As a presidency, we will start the work in the format of IMEX Working Party, and we will start this work on the 1st April, which is not the prima aprilis. We will start with the general presentation made by the Commission with in-depth explanation, with in-depth justification to let member states better understand the proposal, the aim of the proposal. Then on 23rd April, we will continue our work by analyzing article by article in this proposal. The regulation is, of course, extensive, as was said, and contains many new elements.
I'm told that maybe you should speak closer to the mic.
Oh, sorry. Thank you. And contains many new elements which weren't already discussed. As was said, for example, readmission provisions. So it is very difficult to assume what will be the progress on the work within the Council. That's why it's up to all of us, to all of the member states, to determine what level of ambition we achieve. The pace of work and its effect will depend on the commitment of all member states on their ambition.
Thank you very much for that, and we wish you, of course, very good luck. Jasper, you are the executive secretary of the Meijers Committee. The Meijers Committee issued in December 2024 a set of recommendations building upon their assessment of the previous recast of the return directive, which obviously did not come to fruition as we stated earlier. So my question would be very simple. Do you recognize yourself in the Commission proposal? Do you think that the wisdom of the Meijers Committee has been heard by those holding the pen or Brussels? Or do you think that maybe something were still missing? Over to you.
Thank you. Yeah, so in our comment, we indeed recommended, as also the previous speakers noted, a balance between effectiveness, but and at the same time procedural material safeguards and remedies. And for us, the revision of the return system can be an opportunity in several ways. It can get rid of the things that didn't work in the current system, that maintain the things that do work in the system, to align with the pact, and also to pair the harmonization of procedural safeguards with this mutual recognition. And with that in mind, and looking at the proposal, we have seen some positive elements in the proposal, but allow me here to also be a bit critical and stress the fundamental concerns that we have. 4 points that I would like to mention. The first is that a new working system should, in our opinion, always start with an impact assessment on the possible effectiveness and fundamental rights implications. And we do regret the fact that there hasn't been an impact assessment presented by the European Commission. And we hope that in this upcoming Commission staff working document, a more detailed account of the consultation process will be given. Another impact assessment that we think is missing in the proposal is the ex ante fundamental rights assessment before a negotiation starts with a third country, for instance, on a deal on a return hub. We believe this is essential to get a good picture of whether a return hub can be established in the first place. Second point, we noticed a shift from a more voluntary character to a more forced character in the proposal. Mr. Luchner mentioned earlier that it's about both forced and voluntary, but we do see a shift, and that is pretty much I would say the European Commission has departed from its earlier stance in the previous years. There is also what was established in the Return Directive. Indications for it can be found in Articles 12 and 13. For instance, the extended grounds for forced return and also the absence of a minimum time limit for voluntary departure. And a related issue where we also see the removal of voluntariness is the broadened definition of countries of return, country of return, I think it is, which now allows also for returns to countries where people don't have a connection with. We think, well, we look quite critical at this development. We think the voluntary departure option is quite watered down, and we believe, in fact, that voluntary departure is a more humane, efficient and also effective alternative to forced return and should therefore be prioritized. The third point I would like to stress is that we have observed that there is somewhat of an inconsistency between the time limits of appeal in the proposed regulation on the one hand, and the time limits of appeal in the asylum procedures regulation. In the proposed regulation, we see that it's up to 14 days to lodge an appeal, whereas ordinary appeals in the APR range from 14 days to 1 month. And we would definitely recommend the co-legislators to take this into account to create a consistency in with the pact. The fourth and final point I would like to mention today is that while we have seen some provisions that enhanced and also clarified procedural safeguards and remedies, for instance, detention, safeguards, a full and ex nunc judicial review, and there is now also a monitoring mechanism of removal practices. We also see that the proposal has reduced safeguards. And I just mentioned already the time limits, but another good example, I think, is the lack of automatic suspensive effects in the first instance. So all in all, to answer to your question, we do see some positive elements. I think they should be stressed, but at the same time, the Meijers Committee is concerned that the urge for effectiveness comes a bit at a cost of the procedural and individual safeguards.
Thank you very much. I mean, what you just said in your final comment resonates with what Lena Düpont said earlier about the reference to effectiveness. By the way, I mean, you have also a unique opportunity to share your concerns with the two co-legislators this afternoon. So, and I assume that they have duly taken note of what you said. So I'm terribly time conscious, and we definitely would like to keep as much time as possible for the Q&A session. I'm still waiting for questions in the chat box, by the way. So I will limit myself myself to two supplementary questions to the two panelists on my right. There was a reference to the, extended notion of return countries, and it resonates a little bit, Johannes, with the intention which was announced by the Commission and confirmed, even anticipated, to review the safe third countries concept. Can you help us to better understand the connection between this initiative on return and what will come, whatever will come, when it comes to the revision of the safe third country concept? Over to you.
Thank you, Jean-Louis. Just for those in the room who aren't experts, and I'm certainly among those, distinguish between safe country of origin, there will be proposals for that, and safe third country. That is very important. Safe country of origin helps you to guide you in the assessment of an asylum request. So the presumption that is there, but of course, the assessment also has to then always be for and with the individual and the individual's asylum claim. The safe third country relates to countries of transit. And the question being, if you apply for asylum here in the European Union, why didn't you apply for asylum when you were on the way? That is already there, but the question then is, and it's a question on which we have a lot of jurisprudence, what kind of connection do we need to be able to establish between the individual and the safe third country? So that is one of the questions we will have to answer. There are several ways. There's a binary way to say there has to be a connection and we will define it, or to say there doesn't have to be a connection and therefore we don't have to define it. In between, there are quite a few answers, which again need to be looked at from the perspective of feasibility, the perspective of fundamental rights, the perspective of legal coherence, and so on. Another one relates to one of the points that the previous speaker just raised, and that is if you are confronted with an inadmissibility decision, in other words, the EU member state tells you, well, you could have and you should have asked for asylum in country X, does that automatically then suspend or not your right to stay in the European Union? These questions don't fall from the sky. These are the questions that the practitioners, both in the administration but also in the judiciary, ask, and which we will need to answer. And what do we do if we have a presumption of absconding, and how do we prevent absconding in these cases? So I would say those are the key questions we will need to answer. I cannot tell you an exact date on when this will come, because as the President has indicated to her in her last letter on the subject to the European Council, for the moment we are focusing on proposals related to the concept of safe country of origin. Mm-hmm. So the safe third country proposal will come at a later stage. But as was noted, everything is urgent, and maybe I can just also answer the question on the impact assessment. We love impact assessment as officials because you can then be much surer than you otherwise are that you have considered the entire situation. But in this particular case, we had negotiated for years on end with member states, with the European Parliament. We had several studies and analyses of the situation. We have a return coordinator. We have seen the practice. Most importantly, however, we had a request in October last year from the heads of state and government to urgently work on this proposal. The Commission is a political institution, and we did not also, in light of current events, go back to heads of state and government and say, in 1.5 to 2 years, you will get a proposal, because we need to study a question which we have dealt with over the last 8 years in even more detail. And then, as was mentioned, there will be a staff working paper that provides quite some detailed analysis, at least of the problems and challenges we're trying to solve. Thanks.
Thank you, Johannes. When preparing this event, together with EPC, we agreed that we would do everything to prevent this conversation to be hijacked by the return hubs. But yet there will be a question on return hubs, and it will be for you, Lena. Okay, I will not elaborate on the way it is being sketched in the Commission proposal, but one thing which strikes us, or which strikes everybody who reads the proposal, is that actually it will be based on bilateral agreement between member states and third countries, that these agreements will have to meet a certain number of criteria, but nothing is said about a possible parliamentary control on this agreement. And we know how nervous the parliament can be when it comes to these kind of new arrangements, which are, I mean, clinched between the Commission and third countries without the parliament having the opportunity to have a say about that. Over to you.
Well, first of all, thanks for that question, and I try also to do my best to not let return hubs solely steer the debate here, but just probably shortly a small comment on a notion, because it's a bilateral agreement, and member states tend to have parliaments overseeing bilateral agreements from their respective member state. It's not like there is no parliamentary control at all. That is one thing. And the second thing is, because it is based on a bilateral agreement between member states, would be a bit awkward to then add a European parliamentary control for agreements or arrangements that actually member states are doing. So it follows a bit of a logic in that sense. A third remark on that, being well aware of how much the parliament likes to have vibrant debates on arrangements and agreements on various occasions, not only within LIBE, by the way, but also within AFET, within DEVE, within Brouwer. So we have our remits and our possibilities to actually have create not only the public awareness, but also kind of using the, let's say, soft powers of the European Parliament and follow the arrangements of bilateral agreements when member states opt for that.
Thank you very much. And indeed, you're absolutely right. I mean, there are different levels of democracies, and we should never lose sight of what the national parliament can do on this. I have a first question in the chat, so I think that we might now slowly but surely turn to a question and answer part of our meeting. I will suddenly come back to you, Eva and Jasper, with supplementary questions, so that we can, I mean, keep on, I mean, covering all the issues that we had indeed considered that we would cover. So I will take, at least for starting, 2 rounds of questions. I have one in the chat, and I'll take 2 questions in the room. So I see, is there a microphone? Yes, thank you, Anastasia. So I see the lady in red and the lady on the 3rd row in front of me. So if you can, yeah. And by the way, if you can introduce yourself, because I mean, you are not only the lady in red.
No, definitely, but it was a good choice, I think. Katrin Hatzinger, I'm head of the Office of the Protestant Church in Germany, and I'm wondering about one element of this proposal about independent return monitoring. So I would like to know a bit more from the Commission about the reasoning, and also how the Commission envisages that to work in practice, and in which sense this provision, Article 15, I guess it is mirrored also to the screening regulation and the monitoring, which is part of that EU legislation. Thank you.
On the 3rd row, please.
Thank you very much. Silvia Carta from PICUM, an organization working for undocumented migrants. I have several questions. I will try to limit it to those that might not be addressed in the next panel. I just wanted to also maybe make a very quick comment on this question of return hubs, but I really agree that this should not be the focus. But I also want to remind that EU funding can be used for setting up similar arrangements, agreements, and hubs. So I think it's very important to still reflect on the Parliament's, European Parliament's role in terms of how EU funding is spent by member states. The second question that I have is actually relating to security risks, because we're reading so much about how people who have a return decision could be a security risk, but we are not hearing at all how people are at risk as a consequence of their undocumented status. And to make an example, for example, people being exploited in the labor market, people being victims of crime, domestic violence, but still not able to actually file a complaint or to go to the police for the exact reason that they risk being deported. And this is a practice that we see across all member states. And we know that there are several frameworks, the Victims' Rights Directive, the Employer Sanctions Directive, but they're not working. So it's also very important to reflect on these. And I would be very curious to know what the Commission, but also the other panelists would propose in this regard. And then maybe just one more reflection around detention, because this is not featured very prominently in the discussion, but I also want to raise the attention to the fact that there is not only an extension of the grounds and timelines, but there is also an extension of how other so-called alternatives can also be used to legitimize control over people. And I'm just wondering how has the jurisprudence of the European courts been taken into account when drafting the proposal, because I see that there are many divergences, not to mention other practices that are actually being implemented and based on actual trust to people that allow them to live in the community. Thank you very much.
Thank you. And again, I mean, please be conscious, as you stated yourself, that there will be a second panel and that some questions might be more direct, more fitted to be directed to the second panel. I will take a third question from the virtual audience. It's coming from Odilia Abreu. I hope that I pronounce your name correctly. I mean, the question is the following: what concrete mechanisms and safeguards can the EU implement to ensure that fundamental rights are fully respected during asylum procedures in key third countries? Considering the complexities of the cooperation with non-EU states, how can the EU effectively monitor compliance with international human rights standards and ensure accountability in cases of rights violation? Might have something to do with the return hubs of the notion of safe third countries, but I would leave that. Well, I have the feeling that Johannes and Jasper, these questions are mostly directed to you, but Lena could certainly wish to add anything to the initial answer that will be given. So Johannes, please.
Okay, thank you. I didn't mention the return hubs in my presentation because I knew they were going to come up. And quite honestly, for us, that was one of the less difficult parts to write and formulate, because all we wanted to do was to reflect the request of the vast majority of member states to create a legal basis for this to be possible, not more and not less. However, in answer to the last question, I would point out that the discussions we did have were about how you protect the fundamental rights of returnees that would go to return hub. Therefore, the precondition that there needs to be some sort of agreement, accessible agreement or arrangement with a third country, and that agreement or arrangement would have to fulfill a number of conditions which are listed in the proposal. And one of them, or rather, there is then follows an obligation to have a monitoring mechanism in place to exactly do what you asked. How will this be done? This mechanism is not voluntary in the proposal. It is an obligation that needs to be in place. That leads me to an answer on the first question, the monitoring of removals. Now, on the jurisprudence, I'm not a lawyer, I'm an economist, and in DG Home, I am a minority of, I don't know, 3% maybe. So yes, it's all about jurisprudence, it's all about the law. The discussions are always about, of course, clarity of formulation and all that, but basically it's about fundamental rights protection, while making the system more responsive to actual practical operational questions. So removal monitoring, it's part and parcel of the pact. We have obligatory monitoring in the pact, for instance, for the border procedure, for the entire procedure that is described in the pact, always with a particular emphasis also on minors, particular unaccompanied minors. That is a big question, by the way, for member states. I deal with 2 member states directly, which is the independent institution that we can choose to do that, and how much more do I need in terms of resources and people who actually do that. Now, some of our member states, if you think of Spain, this is a challenge. It's a big country, big numbers of arrivals. So you need to cover a lot of territory, including and in particular the Canary Islands. So what we want is a mirror image of that for the entire removal process. If you put people on planes, particularly if you force them, that's what removal is, to go on a plane, to be guarded by guards, to be flown home against their will, if you will, then you need to monitor how this is done, and that any kind of constraint or force applied is proportional. Now, this is very important for the protection of the fundamental rights, and therefore we foresee it, and we are working on that already together with the agencies. But it's also very important for the third countries. There is no third country that will accept that its citizens, criminal or not criminal, doesn't matter, are subject to non-proportionate use of force. So it is on the one hand a fundamental rights guard that mirrors what is in the rest of the pact, but on the other hand also something we absolutely need to make sure that third countries accept that we respect fundamental rights, that we respect due process, and so on. On the question of undocumented migrants, it's a good question because, when I hear these debates about hundreds of thousands, millions of migrants who are somewhere here, I very often ask people, okay, where are they? And of course, many of them are in the labor market. We know that we have also a lot of people who are employed illegally. We also know that quite a number of the migrants, I hear that, for instance, now in the discussion on returns to Syria, when you then discuss returns, member states will tell you, yeah, but this percentage of doctors in my country, I want to keep. I don't want them to go back. But the answer to your question is, it's not because you're undocumented that you're being removed or returned. You can ask for a status, you can ask for asylum. If it then turns out that you don't have a reason for it, then you might get a negative asylum decision and a return decision. You can also ask for subsidiary protection, which in many of those cases would probably be more appropriate. But you're probably a victim of crime also. Our effort, to be honest with you, since DG Home in particular is not a labor agency, but we are responsible for the Employer Sanctions Directive, our focus is very much on efforts to fight migrant smuggling and human trafficking, which is the organized crime part of it and the worst part of it, I would say. But of course also on the Employer Sanctions Directive. And on how member states deal with that. But again, we just had recently a case of migrant smuggling in this country, actually, of women who were sexually exploited. And not only was there no question of removal, but there was a question of sharing their names with their country of origin because the authorities saw certain risks even in that. So. It's not automatic that you say you're illegal, you go. You then have to follow due process with people like that as well. It's true what is new in here is obligations for the individual. But quite honestly, both Jean-Louis and myself were for a long time in humanitarian assistance. If somebody comes and refuses to say who he is, where he comes from, why she's here, refuses to tell you their name, their identity, then you have to act upon that. And you can't treat an individual like that with somebody who says, here's my name, I'm asking for asylum for the following reasons, and then you apply the procedure. I think it's logical that you need to deal with these cases based on the willingness of somebody to cooperate. We also, just to finish, I mean, we also have a certain naivete in our system, which dates from previous times. We have member states where a return decision has to be delivered by mail, registered letter to the address of the individual. So already, if you don't have the address, you have a problem, because how do you communicate? And with 48 hours of written notice. Now, in practice, that means that there is a certain invitation to abscond. And we believe it's much better to go, talk to migrants, introduce mandatory counseling, as I've said, and inform them where you can about the alternatives. But we need to take into account, we also need to take into account, I'm sorry, but we have cases, we know of cases where unaccompanied minors are being forwarded to the European Union as the spearhead, which then serves for family reunification, and the rest of the family can follow. And since it's an unaccompanied minor, it's particularly effective because legally, of course, the constraints are much higher for an unaccompanied minor than for an adult. These cases exist, and therefore you need to take them into account. However, last point, this is not the majority of cases. This is not the majority of migrants. And we emphasize so much in this proposal as in others, the analysis of non-refoulement before you return somebody, the protection of fundamental rights, the monitoring, etc., exactly because we know that in many cases, migrants cooperate, accept return decisions, and in the vast majority of cases, I want to emphasize that, and that's also a reflection of our policy, returns are indeed voluntary. That's the vast majority. We want to keep it that way, and we want to actually increase that number and reduce the necessity of removal. Thanks.
Thank you for this very comprehensive.
Yeah, maybe on the how the question how to protect the fundamental rights of third country nationals regarding return hubs. Yeah, So I think by nature the return hubs they involve some risks to fundamental rights. We have seen that in previous deals with third countries. I think a question there, and a fundamental rights agency has already taken a position there, but a question that can be raised is like who manages the hub and who's responsible for further removal, and I think that's quite important for the accountability question that comes up. But if basically answering the question like how to protect, I think there's a couple points that I would stress. I already mentioned the ex ante fundamental rights assessment. I think that is important to have before the negotiation starts. So there already an assessment can be made on whether there are a risk of arbitrary detention, of refoulement. Also, what would be the role of Frontex in this situation? The second thing that I think is important is that, of course, there is a deal, but it should always be based on an individual assessment. So it should be based on an individual return decision, also based on an assessment of any risk of refoulement. A third point is already there in the proposal, is the monitoring mechanism about the implementation of the return hub. And I think a fourth point that I would add is that there would be effective remedies for the persons involved, and also a complaint mechanism. I think we have seen these points also in situations of Frontex status agreements with third countries. So I think that could, to some extent, address the concerns that there are with regards to fundamental rights. But again, stressing that by nature, return hubs do involve, I would say, some risks to fundamental rights of people.
Almost impossible to just say a few words on what has been discussed so far, but maybe some reflections, some comments from my side. Sometimes I do have a bit of a feeling that we tend to forget that return actually follows a completely and completed asylum procedure, with all the safeguards and with all the actors involved that are due to be involved in an asylum procedure. So it is let's say, a second step after indeed a negative asylum decision in that sense, now also encountering the effectiveness, because we shortened the period between the negative decision and the return decision in the previous term. But again, then it is already clear that there is, at least on the grounds of international or subsidiary protection, there is no right to stay at the European Union. And there is a certain logic, well, that also needs to be followed through. Also picking up a bit on what Mr. Luchner just said, that indeed it also depends on the cooperation and the willingness to cooperate of the applicant and later on the returnee, because it's a basic principle of our legal system. It's a basic principle of how to provide international protection, that we can actually also guarantee protections to those who are in need. We also need to be firm with those who are not in need. And on the question on whether and how we can safeguard fundamental rights, the implementation, monitor also the implementation and upholding of fundamental rights, well, I think without agreements, or be they bilateral or indeed at European level for other questions, I mean, without having an agreement, we can't monitor much. We have an assessment of the situation, but we can probably deliver better if we have an agreement that not only we can monitor then, but also indeed incentivize improvements on the ground. And this is basically, I think, the underlying question there. Do we just simply accept that there are third countries where there is a dire situation, not speaking about return hubs, because this is something different here, but speaking about also the link between development policies, between humanitarian policies, asylum and migration flows, and so on and so forth. I think the basic underlying question always is, do we just simply close our eyes and say, well, it might not be nice, but it's not our problem? Or do we try to improve the situation the best way we can? Knowing that this is a very tricky and a difficult balance whenever it comes to third country cooperation. But the very aim should always be, at least from my perspective, that we try to improve the situation on the ground for those who are either in any case there because they are already on the move, or they are returned to that specific country for various reasons. I think that this should be the driving aim also of third country cooperation and agreement, of course, in a more positive and constructive notion when it comes to third country cooperation as such, in the broader context of combining economic question with capacity question, with indeed legal migration capacities, and so on and so forth. So it's always a combination of everything, where there might be the addition then, of course, to it that you actually need to take back those citizens of your country or of other countries who are about to be returned.
Okay.
If I may, just very quickly, so that we got the wrong impression on the return hubs. I think one thing in continuation of what Lena Düpont said, we need to consider demystify a bit. First, there is no agreement, there is no arrangement for the moment, as far as I know, specifically on asylum seekers who have a negative asylum decision. Second, we always emphasize, and rightly so, that 70% of the world's IDPs, refugees, are in the global south. And I have seen, and Jean-Louis has seen, refugee camps in Kenya, for instance, with massive numbers, huge operations with Somalis, with other nationalities. Most of Sudanese refugees are in one of the poorest countries in the world, in Chad, and they are being treated humanely and well, based on what these countries do. So I wouldn't start with the presumption that there will be massive fundamental rights violations. I think that would really do injustice to most southern countries. However, on what was being said, it's true there is no complaints mechanism that I give away. However, please, if you read the legal text, we say clearly an agreement or arrangement may only be concluded with a third country where international human rights standards and principles in accordance with international law, including the principle of non-refoulement, are respected. In other words, there needs to be an analysis of these questions before you enter into an agreement, and you need to notify other member states and the European Commission before you enter into an agreement and arrangement. And of course, the question of refoulement chain was very high on our mind. This was also a comment we got from UNHCR. So therefore, it says specifically the modalities of onward return to the country of origin or to another country where the third country national voluntarily decides to return, and the consequences in case where this is not possible also need to be specified in the arrangement or agreement with the third countries. In addition to that, you then have the independent monitoring mechanism. So I believe that we have circumscribed that from a fundamental rights angle quite effectively.
Okay, from that moment. Thanks a lot. I'm absolutely aware that I'm eating on your coffee break, but still, I have two questions in the chat, and I will take two more questions in the room, provided that they do not deal with return ups. So in the chat, the first question comes from Luna Lozano, and it has to do, I will synthesize that, with funding mechanism for assisted voluntary return program. Is it for something foreseen to increase or supplement this funding mechanism in view of making the AVR option even more palatable, taking into account the new approach with restricted deadline, which is foreseen in the regulation? The second questions come from Marie Martin from the Parliamentary Assembly of the Council of Europe. So Marie, I hope that you will allow me to somewhat synthesize your question. It has to do with the cooperation between the European Union and the Council of Europe when it comes to monitoring of fundamental rights. I mean, the Council of Europe has elaborated standards, is taking a series of initiatives, including monitoring and assessment. And the question is there any intention or is there any existing mechanism which would allow the European or facilitate the European Union to take this into consideration? There are two questions from the audience in the room. I see one and there, the gentleman, and another and there. Okay, thank you very much.
Thank you. Here's Brouwer from the Belgian Immigration Office. Just first a comment. Mr. Luchner talked about the readmission case management system. Yes, we have that in several third countries now, and it is working very well. I was one of the pilots, let's say on Belgian level, working with that readmission case system. But there's also we cannot make the comparison between return case management system and readmission case management system, which are two different things. Return is much faster, of course, and there is going my question. No return without readmission. But how far are we willing to go in the negotiations with the third countries? Because, of course, we see already some mandates of the Commission with third countries where the third countries are stalling for several years, and where it is clear if we talk with them informally, they rather want to negotiate on a bilateral level with the third countries. And of course, they want to use that kind of leverage by saying, yeah, we want this and we want this. So how far are we willing to go in those negotiations? By in Dutch we say we give them butter with the fish. So some added support for this and that. I recall our Moroccan friends saying we want 500 boats and so many night visions, etc. For example, but also linked to that, the fact that we see that there is a non-willingness for third countries to cooperate, and we have the nice mechanism of 25A in the visa mechanism, which is not working because all the members, it works on a limited scale, because of course all member states have a say for which third country they want and don't want to make those sanctions. And some of the bigger issue countries, there is a clear unwillingness of the member states to go further. Thank you.
Thank you very much. The lady at the other side of the room there. Could you raise your hand again? Yes, thank you.
Very much. Linda Rabo from the UN Human Rights Office here in Brussels. I had a question on the return house, but I will keep it for later maybe. But so turning to the mutual recognition principle, just a question there on, I guess this would be perhaps for the Polish representative or the Commission or perhaps both. How would you see this principle being implemented in the absence of a harmonized condition for legal stay across the EU? I mean, we've talked about, of course, asylum procedures, but I mean, I hear this dichotomy between asylum and return, but of course, not all migrants do apply for asylum. And indeed, at member states level, there are quite some different sort of legal frameworks when it comes to regular admission and stay, including based on humanitarian considerations and other pathways for admission and stay, even beyond international protection or subsidiary protection statuses. So in presence of this fragmentation and different landscape at national level, which is not regulated at the level of the EU, how would mutual recognition work? Or is there sort of an intention to also look at sort of harmonizing those conditions as well? I mean, there is indeed an exception on public policy grounds when it comes to the enforcement of the return decision by the sort of requested country. So would that also, I mean, would that be an option that would allow member states to indeed refuse to implement the return, enforce the return decision based on those national law considerations? Thank you.
Thank you. I would leave it to our panelists to decide between themselves whether they take one question or another. Many questions, of course, by definition, are addressed to the Commission because it's all about a proposal which is fresh from the oven, but there was also one addressed to you. Maybe we could start with you.
Okay, thank you. I will be quite brief, I think. As for the element of mutual recognition, I perceive it's to be the most difficult element to be negotiated within the Council. As we can see during the previous meetings, there was a strong opposition from some member states' side on this provision of this solution. So I think it will be the main challenge for our presidency to have it negotiated, to have it concluded, especially that from the 2027, from the 1st July, it should be obligatory.
Thank you. So going to be so for sure one of the major hurdles. On the other questions, I mean, starting maybe with you, Jasper.
I think most are.
Okay, very good. So Johannes, Lena, please. And Parliament.
Well, thanks for that. On an institutional perspective, maybe just shortly 3 comments to the question that have been raised. Especially also to those who were not yet able to either ask their question on return hubs or refrain from asking a question on return hubs. I think we can rest rather assured, everyone here in the room, that there will be a political debate around that for quite a while. So I think that there is enough room also to refer to that later. To the mutual recognition, I mean, I think it's sometimes also a bit of a time to remind ourselves that actually what we did with the pact, what we're doing properly with return now, is a bit of a baseline work here. So we actually, for the first time ever at European level, have something in it that could be really called a common asylum, not yet migration, but asylum policy. So on the rest, we're working. But I think it's sometimes worth reminding ourselves that actually home affairs and thus asylum and migration is still one of the youngest policy fields we have at European level. So of course, we're doing a lot of work that requires long discussions. They could be shorter, but finding an agreement between 27 member states, 3 institutions, and various political families, of course, requires a bit of a time. So indeed, saying here again, mutual recognition, I guess Parliament is a bit more relaxed than the Council on that. We might also be a bit more ambitious in requesting that, but I think that this is something that could actually really be, it sounds like a small tool, but it could actually create a huge relief, I would say, on member states as well. Which leads me to the last comment on the question of readmission, the visa suspension mechanism. This is why I was also a bit reacting in a sense of, I think there sometimes member states could do a bit better in expectation management, because they tend to request a lot from the Commission in terms of let's do that together because we all can combine our forces in our weight at political international level and so on and so forth. But when you're digging into the details and you do want to set up something in common, each and every member state has another point to say, well, probably not there, or not with that regard, or not with that instrument, or so on and so forth. So, Article 25, I mean, it's not like we had reinvented the wheel there. It just needs to be applied, and member states can already do that if they want to. And of course, the weight also in third country cooperation is at the utmost if we combine our forces together. But this is probably something not necessarily for the Commission or the Parliament, but for Council, or not for Council, but for the Member States.
Johannes.
Yes, on the question from the colleague from the United Nations, same answer in less elegant terms. We now have a common asylum system, and it's clear there are divergences in the recognition rate, if you will, for one and the same country that are so large that you say there are different interpretations also by national courts, but it's a bit of a catch-22. And of course, what it's about in the end, the concern of member states is absconding and secondary movements. If you have one large country that doesn't mutually recognize, then the theory goes, then everybody will abscond to that country, even if they already have a return decision, because it won't be applied. The exception we introduced that you mentioned, contrary to public policy, is rather large as well. But we still believe that this can be made to work. It will require intensive work also by us, in particular by the return coordinator with member states to get it going. And then, of course, we have a judiciary that will make independent judgments on that. On 25A, I don't want to mention anybody's names, and I share part of your assessment, but I would say it does work. I've had countries which for 2 years told me, we don't negotiate with you, you put nothing in writing and still negotiate it, and who have come from a position of zero return, no return, we don't accept the principle of return, to full return, to the satisfaction of the member states most concerned. We have others that continue to refuse. However, I've had a few hard cases where the position changed once measures were proposed and or adopted. I would say it's not the measures themselves, it's those third countries who value their relations with the European Union at such a high level that they don't want to be on a list that includes irritants. So it's more a political decision than one that relates directly to visa measures. That being said, if you compare our visa measures to other democracies' visa measures, we could have a bit sharper teeth, but we have what we have. We work on that. On assisted voluntary returns, if the question relates to returns from the European Union to third countries, we absolutely make sure that we have some sort of assistance, in particular reintegration assistance, but also not only short-term, but also medium and long-term assistance in place. If it relates to the AVRR programs from Northern Africa to Sub-Saharan Africa, as you know, those work very well. They save lives. We don't know how many, but it's thousands because people never cross the Mediterranean. And we have, from the partial evaluations we have a relatively high success rate. As you know, we do those mostly with IOM. Success rate in the sense that people who then receive the reintegration assistance at home, the vast majority of them, depending on the evaluation, plus minus 80%, decide to actually stay and not go on the trip again. And it's for all these reasons that we are absolutely adamant, not only that we need to continue, but we also need to expand. Also for one very simple reason, apart from the fact that this is the most dignified option for most of the concerned people, but also because the countries of transit are willing to cooperate because it's their problem and they need to solve it. It's their challenge, they need to solve it. But it's also easier for countries of destination to accept returns from another African country than from somewhere in the European Union. So for all of these reasons, we want to reinforce it. We are, as you know, budgetarily rather constrained, but I would expect also that in the discussions on the new multi-annual financial perspectives, this will feature because it is efficient and it is effective. And both of those together in migration management, as you know, is a relatively big challenge to achieve.
Well, thank you very much, Johannes, and thank you to all panelists. I think that the time has come to bring this panel to conclusion. There will be more in the second panel under the skilled leadership of Alberto. Eva, by the way, you will notice that I spared you the nasty question about how do you deal with schizophrenia, being in charge of the negotiation of a key element of the return pact. At the time, Poland is not amongst, the Polish government is not amongst the strongest supporter of the pact itself, but I will spare you that question. A few words by way of conclusion. And of course, I mean, being the dinosaur than I am, you say that it was a relatively young policy field. I could not refrain from looking at the 2002 communication on return and return policy. At the time, the Commission said that to implement, to develop, to frame and to implement a efficient return policy, a couple of things were needed. First, I would say cooperation. Your marching orders were in that communication, Marie. And to that end, a platform was needed. And the idea was that this mandate could be given to the newly born Frontex at the time. Well, by the way, we had invited Frontex to participate into this event this afternoon. It was not possible for them to join because I think that they have a management board meeting as we speak today in Warsaw. Second, money was needed to implement the common return policy. And of course, I mean, then we had the different funds which are still there, and also the external relation instrument. You referred to them, Johannes. Well, by the way, something you said, Lena, about a cooperation with third countries, it reminds me of the regional protection program or the regional protection and development program that are still there and that could be further developed if indeed we move in the direction that you indicated concerning the identification of safe third countries or safe countries of origin. It stated also that we needed indeed cooperation with third countries. And it ended up by saying that, guess what? We needed to have common standards to facilitate mutual recognition of return decision. That was 2002. We are almost there now. In the meanwhile, there was the 2008 directive, which was en français dans le texte, la directive de la honte. That was the first time ever that there were a civil society organization demonstration in front of the beautiful building of Justice and Home Affairs in La Rue de Luxembourg. I mean, the commission was crucified for having tabled that kind of proposal until, once adopted by the council, the same civil society organization understood that it was a fantastic protection shield for the people having been exposed to a ordre de quitter le territoire expulsion decision. And they made a lot of it, which, by the way, explain why some member states might find today that it has been too protective, contrary to what the civil society organization initially thought about this directive. So what does that lead me to? I think that, and you did it perfectly, all panelists this afternoon, it's time to explain again and again what it is all about. It's time for the Commission, it's time for the Presidency, it's time for the civil society organization to have a joint dialogue to make sure that we are all on the same page when we talk about return. For instance, I was shocked by the use, until the Commission released its proposal, by the use of the word deportation. The EU was preparing its deportation instrument. You see, Trump was, the shadow of Trump was there. You said it yourself. I mean, it's not about expulsion. It's once the decision that somebody is indeed in an irregular situation, once the final decision has been taken, at the end of all procedural guarantees and arrangement, that indeed the return directive nowadays and the return regulation in the future will apply. That is something that has to be explained time and again. We hope modestly with EPC that this event this afternoon will help facilitating this conversation. Thank you for having joined us until now. We resume, Alberto, within Helena, the master of ceremony.
Yeah, just a slight change in program. Because we ran a bit over time with this panel, we will extend the coffee break by 5 minutes, but we would ask everyone in the room to be back here at 5:05. And then for those online, 4:05, sorry. And for those online, likewise, feel free to take a short break and maybe also grab a coffee. So see you again in 15 minutes. Thank you.
I'm going to start to talk on the microphone to see if this has any effect on the crowd who's still having coffee, and I'm going to ask the online participants to still bear with us for a few minutes before we start. Your way back.
All right, I think we can make a start. Thank you to everyone for returning back from your coffee break. Sorry again that we had to cut it a bit short, but we do want to make sure that we have enough time for the panelists in the second session to share their insights, as well as to you both in person and online to ask some further questions. I now have the pleasure of opening the second panel, which will focus on implementing the new EU common approach to returns, what operational and fundamental rights implications. This session, as mentioned earlier, will be moderated by Alberto Neidhardt, who is the head of the European Migration and Diversity Program here at the European Policy Center, and who will also introduce the speakers for this panel. So without further ado, Alberto, you have the floor.
Thank you, Helena, and thanks all of you. I'm gonna make an executive decision already now to extend the duration of this panel, and so I hope you don't mind if we will have a full hour. So apologies in advance, but I think it's best if we continue until 5:10. Indeed, in this second panel, we want to build on the exchange in the first one, and I'm sure all of you have heard a lot, and there's a lot to build on, and we're going to focus on practical questions relating to the implementation of the proposal, but also explore key considerations relating to fundamental rights protections, and many questions have been raised already on both points. I think also in the interest of time, and because our speakers, I think, need no introduction, as you know them very well for the excellent work that they do, including on this topic. I'm going to go straight into the logistical aspects, particularly for those who were not here in the first session. Just as a reminder, we're going to have about half an hour of panel discussion. So a reminder to our speakers to please keep your answers short. I'm a bit more impolite than Jean-Louis, so I will cut you short if you speak for more than the 3-4 minutes allocated. And a reminder to our audience to already feel free to raise questions online if you have any, but also be ready to raise your questions as we move to the Q&A. So without further ado, I'm happy to make a start by raising a question to you, Mari, and this in a way is connected to something that the Deputy DG has already said at the beginning of the first panel, and it has to do with the gaps under the existing framework. And of course, you have a privileged perspective, I would say, into what are the operational shortcomings of the current framework, but also a clear understanding of what the needs are for running an effective EU return system. So to break the ice a bit, I think it would be good to hear from you on what are the key elements from the Commission's proposal that you think are going to play a key role in addressing these operational shortcomings and make the EU return system effective.
Thank you, and good afternoon, everyone. Thanks for the opportunity to contribute to the exchanges today. Something I need to say first, because we have a tendency to speak about returns, it's world of its own, but it's only a measure. So you are a very knowledgeable audience, and you know what is at stake without effective returns. That's the credibility of asylum and our migration management system as the functioning of Schengen information, Schengen area. Actually, what I would like to say to start with as well is that when it comes to returns since 2022, we have doing much better than before. We had the COVID that basically dramatically cuts return activities. Every year, we have returned more than 20,000 people more. So looking at from 22 to 24, and I'm now using Frontex operational data where most of you don't have access, we have about 46% increase overall. Also, we have been working hard to make our system look like we would like to look like. More than half of our returns are voluntary returns. Looking at the Frontex, now the important actor, 64% of Frontex supported returns were voluntary returns, 80% of them on scheduled flights. More than 10,000 people profited from a European reintegration program last year alone. So we have been really working hard to make returns work. We have been also folding the system to look like we would like to look like. Nevertheless, our asylum system is under pressure for 3 consecutive years. So we have more than 1 million asylum seekers. Also, when you look at the news, you don't find member states giving up temporary internal border controls. They're extending them and new countries are joining in. So even if we have been able to make things work better with the tools that we have, we are in trouble, and that's why we need new tools and a new legislative framework for our work. That's also my conviction after almost 3 years on this job. I wouldn't like to give you like a list of, there are lots of things that don't work out, and I think they have been mentioned here, but I would like to look at things from slightly different perspective, and I have said that in another occasion, and Izabella was on that event, and I know some of you were in that recent ECRE seminar where shortcomings were discussed. For me, that there are 3 things that need to be addressed, and I think we are addressing them in the legislative proposal. So first of all, our system is extremely fragmented. It's at national level. We have a number of stakeholders. Things don't work between member states. We have an issue between member states working with the EU, working with Frontex. Frontex is getting from same member states contradictory requirements for support that is needed. And then looking at what is happening at the EU level, decided and discussed in one network is something very different in another network. So there is a high degree of fragmentation there. And you can just imagine how this whole thing looks like when you are in a third country, look at how the EU is working on return and readmission matters. It's quite, our approaches vary a lot. The second thing is the lack of case management, and this is a strong point also in the operational strategy that steers my work. So we are not very good at managing the return cases. We are not very good at using those tools that we have put in place. So we are doing a lot, I'm doing a lot, but it's not really going in the good direction or the direction that is well enough. And the third thing is that we don't have common priorities. We still run the return business like our national business. So we come together, we are whining and complaining about things, but all of us, we do our own things. And those calls that, yes, we need to join effort, it does not necessarily materialize. So now looking at the proposal that is on the table, fragmentation. So we are proposing a common procedure that covers both return and readmission. We want to see a seamless process from negative asylum to voluntary return and then to forced return if voluntary returns don't work. Also important thing is that return decision is not valid only in one country. It is valid basically everywhere in the EU with the European Return Order that enables mutual recognition and enforcement. I have worked mainly in the context of EU borders and in the context of Schengen. And for me, we have common measures for Schengen area. We have a common area. We have a refusal of entry. We have an entry ban. So it's somehow very strange that for return, it has been very national undertaking until now. So it just doesn't go together, but I do understand that things should likely different from asylum and migration management point of view. Also, the good thing in the new proposal is that the scope of the cooperation between member states is defined. So we have a common procedure, we have a decision that is valid everywhere, and also how member states are working together. What is the scope for that cooperation is also defined there. Also, what I think is very helpful is that even if the integrated border management in the EBCG regulation says that integrated border management is a shared responsibility between member states and the agency, we don't really see it happening. Its returns are very much run like a national business, but the regulation proposal says that they are a shared responsibility between member states and union bodies, offices, and agencies. And these actors, they must have common priorities. They have, there should be synergies. There are shared interests, and I think these are very important things that we kind of we should have them, but we haven't had them. A few words about the lack of case management, if you allow me. Obviously, the obligation to cooperate, that's a kind of quite a big game changer. It's a lot easier to manage your cases if the person with whom you're working has an obligation to cooperate, and that mirrors the asylum procedure regulation. Important thing, and something that has been a consistent finding in all Schengen evaluations, is that return-related work, well, they're not sufficiently resources, but the proposal says the competent authorities, they need to have adequate resources. They need to be adequately trained. I think it's really important. Sounds like an obvious thing, but obviously this is not obvious thing, given that it's a shared responsibility in member states, and it's not really there's not one place where there would be an overview of availability of resources. Also, what I like, and it is a part of the operational strategies, the regulation states that member states must establish return and reintegration counseling structures. And they have an obligation to inform returnees. Again, it sounds like, well, common sense thing, but it's not a reality in many countries. We can see that since we have the strategy for voluntary returns, and we have been investing, having these capabilities and capacities in place, there's a lot of training coming up, and there are good results coming up. For instance, last year, Frontex had 19,000 sessions to counsel migrants, and these sessions led more than half of them led into declarations to return voluntarily. Those things actually make a difference, and they matter. And now they are there showing that they should become mandatory. Important thing is that we have this interplay between voluntary returns and forced returns. So that's an important element there, because that's what we have been discussing. And there, for me, the return hub comes in the picture, because experience from the operational side is that voluntary returns work when you have a credible forced return option. So for me, the return hub has only the function to serve as that credible forced return option, but actually we want to work in a way that it's always a voluntary return case. And then finally, about the common priorities, well, it's clearly said the member states and the union must identify common priorities and ensure that they are followed up. I think the Article 25A was mentioned here, and one of my headaches for me has been that if we have discussed on measures to be taken, I don't see them being followed up operationally. So that has been one of my jobs to remind that we have this measure ongoing, and these authorities have said, our doors are open, return the people, but you are not doing that. And my job has been to try to kind of remind member states of this important thing. And one last thing in relation to common priorities, again, sounds like a flat thing. Frontex is a big actor for us, and its role is in growing there. The Frontex approach to return is that Frontex does what member states are asking. When we have tried to little bit make them prioritize certain things, what we see coming up as a priority is also from Article 25A, Frontex has been leaning back and saying that we do what member states ask, and don't you try to politically interfere, because we only do what member states are asking us to do. Now, also here, it is clearly stated that we have these common priorities, and also Frontex has to follow up those priorities set commonly. So I see there are a lot of good things coming from the proposal to remedy these fundamental challenges. Thanks.
Thanks, Mari. And I let you talk because actually you also answered my second question. And so in this way, you actually stayed under the 8 minutes. Moving on then to Virginie, because I think your remarks speak also to the importance of creating what is truly a common system of returns, which are the words used by Commissioner Brunner in the clip that we played in the beginning. But of course, there cannot really be a common system unless its implementation is streamlined and effective across all member states and across all stages of the process. And some of the things that you have mentioned now speak to that urgency and priority. Now, I want to turn to Virginie to ask for your assessment about how far we are from achieving a truly common system. And the regulation also mentions some specific elements and components of that common system. So how far are we from that under the current framework, and does the proposal in your own assessment bridge the existing gaps?
Thank you, and thank you for the opportunity to contribute to the debate. Yes, starting with the beginning and the current situation, that's true that the migration and policy context has changed a lot over the 15 past years. And compared to the more recent reforms, the return directive feels a little bit outdated, and there is a need for a more modern instrument. This is true, and I think we all agree, it was said by Mari and also by the Commissioner, that the fact that we built the return policy on weak foundations has led to a fragmented picture across the EU, with practices on return shaped by national legislation, available capacity, and also national priorities. One concrete example of the procedural gaps in the return procedure is, for example, the criteria to assess the risk of absconding and the content of the return decision. They are quite divergent from one member state to another, and of course with different outcomes for the third country national concerned by the return procedure. Looking to the proposal, the main objective of the proposal are to increase the efficiency of the return procedure and to simplify the procedure, but it is also to achieve a higher degree of standardization to bring more harmonized outcome on return across member states. And you talked about the key component of the proposed system. To me, there are two categories of components, the procedural ones and the operational ones. The common procedure and mutual recognition are clearly procedural aspects, but the others, capacity, digitalization, coordination, and cooperation, are more operational. Legal provisions can help to bridge procedural gaps, that's clear. But when it comes to operational issues, I think legal instruments are not enough. And if we focus briefly, because I had to choose an angle to stick to my speaking time, if we focus briefly on the procedural side, the new proposal provides common rules for certain elements, such as the risk of absconding, the removal procedure, and this is clearly an improvement compared to the current situation. But there are other aspects that remain almost untouched, and this is the case for the return decision itself. There is still no common understanding of what a comprehensive return decision should include, which is the core of the procedure. So maybe it will change with the Implementation Act on the EU Return Order, but for now, there is just the addition, this common addition of the mention of the country or countries of return. So I would like to touch upon also on, reinforced rule and expanded provision on the detention and alternatives to detention. We know that currently alternatives to detention are underused by member states, mainly for operational and practical reasons, even though alternatives are way less costly than detention. And this is not, for example, really addressed by the proposal. And my point here, I mean that providing stricter rules does not always make the system more effective. And detention is a good example because it requires a lot of resources for a country. On the operational side, I believe the proposal sometimes tries to solve operational gaps by introducing new obligation, and that can sometimes backfire and be viewed as counterproductive. So my conclusion would be that I think the proposal partially addresses some needs, and we clearly see the attempt to improve the system, but also while keeping a balance that avoids too many fundamental changes for member states, which can also be a way to facilitate and accelerate the negotiation within the Council. Thank you.
Thanks a lot, Virginie. And I promise you, Mari, I will come back to you on the question on capacity, because I'm sure that you will have some reflections to share on that. But let me now turn to Izabella. And my question to you concerns what has just been mentioned by Virginie, which is the aim of speeding up as much as possible the return process. And when it comes to these, as well as other changes in the proposal, the Commission acknowledges that these should come with fundamental rights safeguards, which are mentioned time and time again in the proposal and in the communication. My question is very direct. Does the proposal set sufficiently strong standards in your view? And does it address and close the gaps which already exist under the current framework?
Thank you so much for the questions, Alberto. In my brief intervention, I'm gonna look at four key elements, and then I will just add a few little bonuses. So I will be looking at the proposal from the lens of a study that I had the pleasure to conduct for the EPRS in 2020, which was the implementation of, which is assessment of the implementation of the Returns Directive. And question is how much the proposal looks at the findings of that study. The proposal says that the study has been carefully considered when elaborating the new proposal. So a first point of mind, the non-refoulement principle. According to the EPRS study, the current directive does not contain an explicit non-refoulement exception to the obligation of issuing the return decision, but this gap can be bridged by a joint reading of human rights clause in Article 5 of the current directive and the possibility under Article 6.4 for member states to issue residence permit on compassionate or humanitarian grounds. However, the PRS study also noted that this clause, the possibility of member states to use, to issue independent residence permit, is underused. Against this background, we have to notice that the proposal does not list the current possibility among the exceptions to the obligation to issue a return decision. So this is not anymore exception, but this is mentioned in a different provision. And it says that on this grant, so the possibility of granting independent resident permit is not to be considered as a possibility of not issuing the return decision, but only to withdraw or suspend it. In the second, on the same line, the risk of non-refoulement, according to EPRS study, is not systematically assessed by authorities on their own motion when complementing the return decision. So here, it's something positive that the proposal proposes or sets out, is that the compliance with the principle of non-refoulement should be verified by judicial authorities at the request of the person or ex officio. So this is something new and it's positive. However, again, we see it after. So once the return decision is issued, so we see again how much the subsequent procedures are important. And this brings me to my second point: the procedures, the remedies. I mean, so according to the EPRS study, currently, or at that time at least, there were various bodies which were involved in consideration of appeals. So the proposal proposes something again positive, which is the judicial bodies are to be empowered to consider the appeals. Secondly, the time limits for the person to submit an appeal. At that time, there were three general time limits. Short one around, depends on the state, but more or less 5 days. The middle one around 2 weeks, and the longest one around 1 month. And of course, the EPRS study was mentioning this lack of harmonization. So now the proposal does try to provide some harmonization towards 2 weeks. So 14 days, which is the middle one. However, it's on a maximum period. So this is the maximum 2 weeks that the person can have, which of course does not prevent the countries imposing 5 days. So again, not much harmonization. And then quickly on suspensive effect of appeals, so EPRS study noted that currently many countries did not have at the time automatically suspensive effect. And this is, unfortunately, that gap is quite reinforced in the current proposal. Very briefly on detention, I know I'm almost running time. Just maybe quickly on. Okay, so detention. So entry bans, I keep it for questions, answers. So detention, the EPRS study mentioned that recommended that the use of detention should be a measure of last resort, imposed only when there is a clear and genuine risk of absconding, which cannot be mitigated by non-custodial alternative measures, and detention should be maintained for as short as possible when removal is imminent. And here we see several provisions which actually go quite much against it. So first of all, the additional free grants for detention, which in addition we can discuss later how they fit in the system of administrative migration-related detention. Secondly, the maximum length is extended from 18 months to 2 years. Plus, a few, but yet very important safeguards were removed. For instance, the detention can be imposed unless other less coercive measures can be applied, and that detention can be extended when there is a reasonable prospect of return. It does not exist in the current proposal. Plus, there is some kind of dissociation between detention and so-called alternatives to detention, which can be imposed even when detention is no more or not lawful. I keep all other points for the question and answers. Thank you.
Thank you, Izabella. And I'm sure there will be questions on entry bans, and we all want to know what the couple of bonuses are also. So take the cue and pick up on this. I want to turn to you, Michele, and do feel free to comment on important points that have been mentioned already. But I wanted to also raise, in addition, a specific question, because we probably will agree that the regulation is quite comprehensive, but there are still some gaps. And one of the gaps that some have noticed is, of course, the situation of persons who cannot be returned or have no or little prospects of being returned. And quite interestingly, again, the communication says that the situation of persons in a legal limbo should be addressed. My question is also very direct. Does the proposal address it? And if it doesn't, why is this a problem?
So thanks so much, Alberto. I think I would also start with a question to all of us. Like, if there's this gap between return decisions and enforcement, is it because return procedures don't work? Or is it because or maybe in addition, many people who have a return decision can't be deported? So I would first also ask who is also receiving return decisions? How is that process actually being developed? We've seen with the Pact on Migration and Asylum that because of the rapidity, the quickness at the border and the new procedures, member states will probably be further pushed into adopting return decisions for people whose asylum application will be rejected. And they won't be looking at other types of permits or other types of criteria for people to be staying. This new proposal requires member states to also order a return decision for any refusal of a residence permit. So we think that this will increase the number of people who are issued a return decision and who don't have access to other solutions. And Article 12 proposes removal only in very limited circumstances when it would violate the principle of non-refoulement or where the appeal has a suspending effect. Suspension for other individual circumstances is discretional, but we see that it's not only non-refoulement. I think, as Izabella has said, it's other areas that should be considered. So physical, mental health conditions, private family life, best interests of the child, they should all be considered. And it remains discretional for the state to repeal the return decision and issue a residence permit. So what I wanted to also kind of highlight is what is also the research and the experience from the field showing in order to answer this question. PICUM is a member of one of the research consortia that is funded by DG Research called MORE, and looking at return and readmission. And so some of these findings are also coming from the research field. And there's three things that I wanted to highlight. One, when we look at people who can't be returned, the evidence from the ground is saying that member states already are having many different types of regularization and residence permits in place. So the current regulation only foresees a limited safeguard requiring member states to provide written confirmation if the return is suspended or postponed. But the research on the ground is showing that the issue is in implementation. So sometimes this confirmation is oral or it's delayed, and it's not actually accompanied by a specific permit. And the research is showing that there's many different cases of residence permits for other grounds. For example, Germany has a residence permit for people who can't be deported on human rights grounds based on Article 60 of the Residence Act. It's a residence permit for at least 1 year. It's renewable. It has a pathway to permanent residence under certain conditions, not dependent on the person's behavior, possibility for long-term solutions. So there's a number of examples. And last week, there was the big Imisque Research Consortium that's actually now, I think, the biggest research consortium, not consortium, but event looking at social science and migration. Last week, it looked at irregular migration. And there was increasing evidence from researchers all over Europe looking at these types of permits and regularization. So that's one thing the regulation is probably not looking at. Another point, and this brings to Mari's intervention on case management. So we've seen through research as well that there's really promising examples when you can do case management properly. But what does properly mean? So it usually means that there's assistance, there's legal aid, there's accompaniment, and that a person's various options can be looked at. So Belgium has an example, for example, between FedAsyl, the Belgian Immigration Office, several cities, several civil society organizations, where this counseling is providing trust, it's providing practical solutions. And we've seen from a long-term project in Utrecht between 2002 and 2019, that in all of the cases with case management, 90% had a resolution. And what is a resolution? So 59% of these cases were regularized, 19% were returned to their country of origin, and 13% were reinserted into asylum shelters. So what we're also trying to look at is how will the new proposal really understand kind of coherent case management that talks about people remaining in the community? And how can EU funding, for example, also with the AMIF regulation, support that? And the last part is we see from the ground for people who cannot be returned that access to services and justice is still a real reality and really at risk and a major challenge. One interesting solution is the Padrón system in Spain, which is basically registration in the town hall. So it's registration to enable people to get access to healthcare and education. It's not a residence permit. It's simply registration with firewalls. So there's many different ways and strategies that are actually very rich on the ground that we see are not necessarily reflected in the proposal, or that the terms are reflected. And so that's the opportunity, for example, on case management to further explore these. I have some other comments that I can also leave for the chat.
I'm sure there will be questions. Thanks, Michele. And before moving to the second round of questions, I will have one at the end for you, Mari, but I also want to, before turning to the others, as the last one will be for you, see if you want to share any reflections on what has been mentioned so far. There was, of course, now also something on case management. So in case you want to quickly respond to them, I will ask you to keep it short, if possible. Thank you.
Hard for me, but I would like to say a few words about case management. I really think it is has the potential of being a game changer in many ways. You, for instance, mentioned the alternatives to detention, and member states are not using it. I mean, that has to do with the fact that in some member states, the only way of managing cases is to detain people. So you inform them, and then nothing is being done until an authority in another context comes against the person and realizes you have not returned. Did you do something naughty or not? Do we have placed in detention? And then you go to detention or you don't go. But that has become like the only way of managing cases. So now this obligation to have appropriate structures in place to manage the cases, and we have been preparing the ground for that. So I mean, there's a lot of work that has went into having different return counseling strategies. There is an EMN return experts group, and there are plenty of studies. So there's a lot of experiences. There are training modules. Frontex is training people. IOM is training people. So that is something, a capability that is well on its way to be established. And I think that now that we really can see that it's delivering benefits, also this issue of absconding, that is a big challenge, and is going to be a much less of a challenge. But you're absolutely right. There has been very little appetite in many countries for alternatives to detention, because they just say it doesn't work because it's not like a tool. That's what I meant, that I said that lack of case management and very selective and limited use of tools that we actually have available to manage cases. So I think that's one thing that I would like to take up. Also for this legal limbo, I think that's the overall what we have tried to achieve already in the back, that we have this so-called comprehensive decision. We have seen it too many times that people who get the negative decision, well, then they cannot be returned. So we need to have this comprehensive decision. The authorities need to give a thought about, so what are we doing about? The non-refoulement considerations are there, but the grounds for getting protection are not sufficient. So that thought has to be there during the process. So not an easy challenge. These are no easy answers, but that has been one of the elements. And then as a one last thing, finding this resolution, well, the residence permits and all that, well, that's not really the Commission competence. That remains in the member states. And we know that there are very different approaches that are being taken. So yeah, that remains the part in the puzzle or jigsaw or Rubik's Cube, as you like to see the what we have in our hands, but it's a difficult one.
Thanks, Mari. And we're not going to go into a discussion on competences in the context of this event. But what we must do, of course, because this second panel would also not be complete unless there is a question on the hubs. And so we do have something to discuss, but we've covered some elements already in the first panel. So I do have a question for you on this, Virginie, more from the practical side, as this is not something that we have really elaborated on in the first panel. And so I'm wondering, again, a very direct question, how do you see the return hubs working in practice, if at all?
Thank you. I'm the one hijacking the debate then. So we said that proposal only provides a legal basis for the creation of hubs. In my opinion, this is a significant development in the externalization of the migration policy. However, the proposal remains silent on how these hubs would operate in practice, and it leaves the practical aspects to member states that would engage in that kind of cooperation with the country. So I would like to warn you that I might be a little bit critical, but in a constructive way, I promise. So yeah, these hubs means that these facilities would essentially be national initiatives, and people sent in the hubs would, however, fall under EU return procedures, but the operational responsibility would lie entirely with the countries involved in the hubs. So I wonder if this can create a gap between the legal accountability and the practical implementation. Secondly, I would like to address a little bit the purpose of the hubs, because I think it is not clearly defined. Is the objective essentially to keep certain categories of country nationals outside the EU territory, regardless of the means? Or is the goal to facilitate their return and reintegration in their country? In either scenario, member states will have to make them available. And in practice, this would involve detention or other forms of restriction of movement for the person concerned. So, of course, these are subject to practical questions. First, the rules on how long people can be held in these hubs, how detention will be reviewed, and what happens if return is not possible. Those elements are not really defined. The proposal provides guiding lines, but that's it. So practical elements are left to the bilateral agreements. And if return does not happen within the detention period, there is a risk that people will remain in these facilities without clear status. There is also a risk that people end up in legal limbo in the third country. And when hubs are located in neighboring countries, there may be other implications, including possible re-entry in the EU territory. So I believe the first point should be to assess both the effectiveness and the intended function of the hubs. Similar setup, and I won't name anyone, for different purposes have shown how complex and legally sensitive such arrangements can be. The legal basis alone is not enough to make them operationally viable. Recent experiences with that kind of external setup highlight the challenges. Those deals made by member states have raised important concerns around legal access, procedural safeguards, and respect to fundamental rights. And also, I think it's the most important point, several past and current examples show that this model is first extremely costly, faces significant obstacles with limited evidence of effectiveness. And to conclude, I would raise a question, because we hear that return hubs will be an innovative solution, but are they? Back in 2018, the European Council already addressed similar solution by calling the Commission to explore the regional disembarkation platforms. And this was finally not followed by any tangible outcomes. Thank you.
Thank you, Virginie. And I think the question on solutions for what is an important one. And I think, Mari, you mentioned that, for instance, hubs could also be understood in the context of incentivizing persons to return voluntarily. I wonder whether there is a shared understanding about what the purpose of the hubs would be, but maybe we can leave that also for later. And I do see already some of the questions coming up. But before we get to the Q&A with the audience, I still have a couple of questions for you. And I'm going to ask you to, again, be brief so that we have enough time for the Q&A. And I want to ask Izabella, because the plan was to discuss a little bit about monitoring, and we could discuss also monitoring in the context of the hubs, but I think there is something else which is important, and this concerns monitoring of the removal order itself, of the implementation of the removal order. And so I was wondering if you could tell us about this stage of the return process, which is arguably the most sensitive one. And of course, monitoring is also mentioned and foreseen in the context of the regulation. So what can you tell us about the proposal? Is it sufficiently strong? And are there any lessons learned when it comes to the implementation of the current framework regarding this?
Thank you. Thank you very much for this question. It allows me to discuss a few positive elements of the proposal. So actually, the forced return monitoring is one of the provisions of the proposal which definitely strengthens the current wording compared to the current directive. So the current directive just says that states should provide for effective monitoring system, and now the proposal provides, first of all, for a much longer and much more detailed provision. So first of all, the monitoring mechanism should be independent, and it should look at human rights elements, because of course there might be various monitoring, no? So it's independent, human rights focus, and should be equipped with appropriate means. So these three elements are crucial elements for any forced return monitoring system, and I find it very positive to see it here written in the proposal. The proposal further provides kind of expansion or elaborates a bit more on that mechanism. So it says that the mechanism should select operations to monitor based on a risk assessment, and conducts activities on the basis of desk review and on the spot checks, which may be unannounced. So here I would say it recognizes that often, because of typically limited resources, the forced return monitoring systems are not often able to monitor all the return operations. So here I think it's a kind of recognition that the operations can be selected based on the risk assessment, which is, I would say, a valid principle if it's used in a good faith. And of course, who is conducting risk assessment on based on which criteria, and the mention of desk review and the spot checks. So of course, in order to be effective and really see what's happening on the ground, the so-called on-the-spot checks should be a majority of cases, and the desk review, I would say, could be just helpful towards selection of the cases. And also the proposal says that some of the spot checks can be unannounced, which is of course a very important safeguard. And then a state should inform the monitoring mechanism about planned operation. So it shows cooperation in a way duty on the part of state, and should ensure access to relevant locations. So I would say it's a list of important safeguards which can allow the monitoring mechanism to function independently and potentially efficiently. I'm passing now to the question of efficiency, which is often related to accountability. So any monitoring, besides recording potential violations and having a preventive function, should also lead to accountability for any violations or abuses that the monitors may encounter. And here it's also another actually positive, I would say protective provision, which says that substantiated allegations should lead to authorities, dealing with it effectively and without undue delay. So here it provides for some kind of dialogue, or at least possibility of monitors to have access to authorities and are called for change. So I would say it's a series of positive elements. And as you ask me, maybe quickly say, how is it now in practice? Indeed, already the current provision in the directive led to all member states having some some form of return monitoring. Typically, some form meaning that often the mandate differs in terms of which part of operations are monitored. And here it's important that also the flight is monitored and not only, for instance, apprehension of the person. So often the devil lies in detail, and in order to be independent and efficient, it should have this safeguards granted.
Thank you, Izabella. And I know this is a bit of a marathon into different elements of the proposal, and so hopefully you will not feel too rushed, but there is one further important novelty, and this has been touched upon also in the first panel. You weren't there, but quite interestingly, and this is mandatory recognition of return decisions issued by other states. And interestingly, we heard that member states might find this to be one of the most controversial proposals in the proposed regulation. Now, the commissioner has highlighted in the video statement that we played that with this proposal, the commission also wants to preserve the Schengen area and reduce as much as possible secondary movements. And of course, mandatory mutual recognition can be understood in that context. I'm wondering, Michele, if you could tell us a bit about the undesirable effects of mandatory mutual recognition, and if in your assessment the safeguards which are embedded in the proposal are sufficient to address some of the potential undesirable effects.
Thanks, Alberto. So I think we see that in Articles 21 to 22, there's harsh punitive measures for people with a return decision who move from one member state to another. So refusal of benefits and allowances granted to the person outside of basic needs, seizure of travel document, refusal or withdrawal of work permit, extension of the duration of entry ban, financial penalties. So we also see that this recognition relies on member states having sufficient resources for the whole implementation of the framework. And it also relies on, as we've heard in the earlier interventions, an expansion of detention. I guess another question is, when we all see how the asylum and migration management system is run currently with, and as I think it was Mari who said, also on residence permits, member states determine their own criteria for residence permits. Currently, regularization is also done in a sense on member states level, but return decisions are also done on member states level. So how will that practically even work when you have so many different systems for determining who actually gets to be returned or not? And also, there's no safeguards actually to avoid duplication of detention periods in member states. So the proposal itself, in a sense, relies on expanding detention, but nothing foresees that the person couldn't be detained maximum in 2 member states. And here I wanted to also bring up something that I don't know if it came up in the first panel, but the situation of children. So I wanted to also highlight in this opening on page 9 on the fundamental rights part, it says the best interests of the child should be the primary consideration when applying this regulation. And it refers to the Convention on the Rights of the Child, and it makes a reference to children. But the best interests of the child, as confirmed in 2017 by the Committee on the Rights of the Child, the Migrant Workers Committee, that gave a general policy recommendation to those 2 committees of the UN to apply those conventions, is that children should never be detained, ever. So it's never in their best interest to be detained. They should always be in non-detention facilities. So there has been a huge missed opportunity here, but could potentially be corrected through negotiations because it's still open. But it is not aligned with the fundamental rights. There is no safeguard here for children because detention is still possible. And that just brings me to the last comment is alternatives to detention, and rightly so. How are we going to get children out of detention? So one way is through alternatives, but what are alternatives? So this proposal speaks about electronic monitoring as part of alternatives. Are ankle bracelets used in jail systems as an enforcement measure? Is that an alternative? We do not think so. Alternatives those are alternatives of detention, not to detention. So what we're trying to look at with alternatives are case management, rightly so, but remaining in the community without enforcement measures. So we have to be careful in looking carefully at what is in here on alternatives to make sure it's not reinforcing detention in a non-custodial. We have to look at remaining in the community. And there's definitely a possibility to redress the situation on children, but currently it's not the case.
Thank you, Michele. And with this, I'm happy to open the floor to the audience, and I'll make sure to address, if there is time, one final question to Mari later on. So I have one question over here, and I think there was a hand raised over there and a third one over there. So I'm going to collect the first three, and I'm going to please ask you to state your name and organization, and also mention who the question is for in case it is addressed to them. Please keep it short and just one question per person.
Yes, this is Rashad from ACRATE. First of all, thank you so much for organizing this timely event right after the release of the proposal. Like many other organizations in this room, we are also still currently analyzing the text and will provide the detailed comments on the proposal. Nevertheless, we were quite surprised with the harsh language they use in the return proposal and restrictive wordings, such as like most of them are punitive wordings and approaches and measures, rather than providing incentives for people to cooperate during the return procedure. That also brings the question of the sustainability of return under the questions. And instead of providing more incentive measures, it's more of punitive measures, more harsh language. If you don't comply with this return procedure, you'll be sanctioned, you'll be detained, you'll be deported, you will be reduced with the reintegration support, you will be banned for the entry bans in this country. So I really don't know how those works and how those incentives work, incentivize returnees or third country nationals to cooperate in the return procedure. So that is, I think, one of the concerns. And of course, as the Commission mentioned time and again, that the aim of this proposal is to streamline the return process. However, when you look at the proposal, it's more complicating the return procedures by adding several criteria, by the risk of absconding, extending risk of absconding, obligation for cooperation, consequences for non-cooperations, and if you take all these measures together, it's very difficult to see how people could opt for voluntary departure. So nevertheless, I want on the proposal, but I would like to ask my question to Mari or to other distinguished speakers who might respond, is regarding Article 7, which paragraph 4 provides that when a country of return cannot be determined on the basis of information available to the competent authorities at the time of issuing return decisions, a return decision may indicate provisionally one or more countries. So how does this going to work in practice? As the readmission procedure is now linked with the return procedure, that following the return decision, the readmission procedure will initiate, whether that will also means that you will initiate several readmission procedure to several third countries to accept these returnees, and what will happen also in the follow-up questions to those third countries who does not respond to the readmission request, or after a certain period of time, they reject the readmission request. What will happen to those third country national? We understand that the Article 14 also have some criteria for postponement of returns, but this does not also include it in their situation of people who cannot be returned. Thank you.
Thanks, Rishad. And with the next questions, I'm going to recommend again that you keep it as short as possible, other than introducing your name. Thanks.
Can you hear me? Yeah. Good evening. My name is Sandro Deserto, currently coming from the academia, but with previous and long time experience in campaigning and policy, notably in detention and administrative detention of migrants and return directive, the previous experiments, let's say. I would pay to keep it short and not to be kind of morally forced to ask this question, but as I'm working at and still believing in this transnational Europe, but coming from the infamous member state who is forcing this example evoked here and there of the detention camps in Shenzhen and Jadar, where I've been 2 times, seeing them empty, and I would like that they will be empty even if they are costing as taxpayer an insane amount of money. So ineffectiveness and difficulties in accountability. So we are kind of pretending and expecting these neighboring countries and especially accession countries, future member states, future member of the family, to be accountable, to be transparent, to fight against corruption. Let's see what is happening in Serbia, what is happening in Bosnia and Herzegovina and surrounding area. And at the same time, we, at least as single member state, pretend to inspire the rest of European community, notwithstanding these policies and future regulation in place, discussed, involved the technical expertise for many, many, many years, and creating from scratch these places in the middle of nowhere. I invite all of you to go there. It's not the most pleasant invitation to go. There are much more interesting premises to see on the Adriatic other side, and paying for nothing law enforcement officers, being ashamed as a European citizen, as a taxpayer and citizen of that member state. And the question is that the Italian government is selling internally, despite the narrative that is, I'm at least relieved that the term of being the last resource was a kind of common consensus there on the table. But in Italy, we also have other kind of examples that we could have exported at least other ways of dealing with people besides third country nationals or whatever. We had receptions in former depopulated villages. One of them, the mayor of Virginie, is even here in the European Parliament now. There is a long legacy of different alternatives and even practices, not all alternatives, vulnerability.
Can I, sorry for interjecting, can I ask you to get to the question so that we make sure that the panel can answer?
Could have been included or at least being inspired by the pact, and the first show disembarkment failed. It depends where failure is. So what's the idea to really have this as a blueprint and example of forcing, even if it's undeniably unsuccessfully from this dear concept of money for value and legal practices? Do we still force this kind of hubs in the future, and why? Thanks.
There was one last question that I have to take at this point, and I apologize for the audience because we're going to go above the 10 minutes that I promised we would stick to. But if okay for you, we stay for another 5 minutes so that I can collect the final remarks from the speakers. But really, please make it a question, not a long comment. Thank you.
Yeah, I mean, it's an opportunity to get back this question on return hubs that I refrained myself from asking before. The proposal recognizes that these agreements will constitute implementation of EU law, including within the scope of the Charter. This may be a question to Mari. What about oversight and coordination from your side or from the Commission side? I mean, I understand that these agreements will then be subject to also the judicial review of the Court of Justice and the enforcement powers of the Commission. Question, in which way? I mean, these will be bilateral agreements. So how do you see your role in terms of ex ante or ex post oversight of these agreements, of these negotiations between member states and third countries?
Thank you for also raising this question, and then also trying to wrap up. I'm going to ask the speakers to come in on any of the questions that they feel they can answer to, and then also to share some final remarks, and at the same time to keep it short so that we can come to an end. And I would start from you, Mari, and then finish off over to Michele. Yeah.
Well, maybe just shortly on kind of answers to these questions asked. Actually, the definition allows for return, there are 7 options to country of return. So that's the one of the novelties. And indeed, at the moment when the return decision is issued, it might not be known due to perhaps non-cooperation of the individual concerned where this return should happen. I think it's in the hands of the case manager to see which one of the options are feasible and whether one is able to win the cooperation of the individual concerned, and that will then in the end determine. But I think I cannot give you any more precise answer than this at this stage. But again, a lot is given to the hands of the case manager, I think, here. As for the third countries, hubs in third countries, indeed. This is something member states wanted, that the possibility is created by the EU law to have hubs. That was done. EU is not planning to open return hubs. Somebody here said we tried, we didn't work out, and probably that is a smart thing not to do. But we know that member states do have privileged good relationships with third countries. They have their own bilateral agreements where EU has not been able to arrive at agreements. So they see there's some opportunities and they think this is a tool they would like to have. But I think it's a cumbersome, it's expensive, and I don't think that anyone will likely go there. And many member states, when the return hubs have been discussed, have reminded this is about creating a dependency on a third country, and we see what that dependency means. So I don't think it is something that is easily and lightly done. And I think, and I would like to think, and my understanding is on these exchanges, that it is a tool in the toolbox, that you have a credible forced return option when nothing else works. That is what in many countries citizens are expecting, that what are we going to do? We have these cases here and nothing is happening. It's not right. So I think there's quite a high number of ministers have written to the Commission to ask for this option. It's not going to be easy. And indeed, there are conditions for that, and there is a monitoring mechanism. And I wanted to say something about this monitoring. I also think it's good that we finally properly define what forced return monitoring is about. And you said here, like, it's one thing is to have it there, describe procedures. I think there's still a lot of work. Even if this proposal would go through and that article on forced return monitoring stands as it is, there's a hell of a lot of work that we need to do in the background to make it actually happen. I mean, you probably all are aware, there's an annual report by the Fundamental Rights Agency that looks at how it is working currently. It's not working well. So clearly there's a need to work on that, to create that common criteria and have that mechanism in place, also have it resourced. There is a lot of work that we have to breathe alive. And as a kind of a final remarks, and all these things to kind of how to make this all happen. I mean, it has not been said, and I have kind of a hope that it would be said everywhere since I started on this job. But in order for us to work together on return matters, we need to be on the same page. And I don't think we are on the same page. We don't have a similar kind of support as we have in other areas of migration to take informed decisions. And now with this regulation, as I see it coming, that we need to have common interests, we need to have synergies, we need to also make sure that we follow up these interests. We really need to be on the same page and have the same understanding. And there is a big piece of work that still is ahead of us. Another thing that is there and it's coming, and we will be addressing, that's digitalization. This resource issue, it's going to be impossible unless we really manage to digitalize also return management. It's completely crazy what we have right now. We have a good tool, that's the return alert in Schengen information system. And member states are trying to use that, but the response times are super long, weeks. It doesn't make any sense. Putting data in manually, taking screenshots from one systems, and then putting and copy pasting on another system, it's not working well. So digitalization is what we need overall, and to also get better with resources, because resources will be limited. As important as returns are, we will never be getting that much resources as we would need. And another thing, I just wanted to put there just as a Frontex was mentioned there, that there's a need to look at Frontex regulation or EPCG regulation. I think there's still quite a lot that has not been really exploited and discussed. One thing being, for instance, this Frontex has quite some capabilities for situational awareness. For instance, I don't see return featuring there much. I think they could do better there. There is a tool called vulnerability assessment, and I happen to be the one who was working on that, actually look at these existing capabilities and resources, capacities, how they're being utilized or not utilized, how training, and now with this requirement to have resources in place, that's obviously the momentum to activate that part also for the service of making returns working better. Overall, also there is a tool that is not really used in a way as it should be, is called integrated planning. So for the return domain, besides that we have operational planning, we need to have capability planning. We need to look at together what kind of capabilities we have placed, and now with the regulation, that proposal that we have there, there's an invitation to have all these things in place and to see that what is available on Frontex to support member states complements what member states have in place. I think these things don't exist yet, so there is quite a lot to explore with the tool. So I think there's a job for me also in the future, just to round it up with that. Thanks.
Thank you, Mari. And I'm going to turn to our other speakers for also their final reflections and any thoughts they might share at this point on the questions. But again, I'm going to ask you to please keep it brief so that we can still finish at a decent time. Over to you, Virginie.
Thank you. Always brief. Then, yeah, first on return hubs, I think, yes, there is a message about return hubs because it will act as a negative incentive on people because they will have basically this choice. Either you go back to your country or you can go back in a country where you have no relationship with and end up there. So I think it will act as this kind of incentive, or member state could be also tempted to use this facility for people posing a security risk because they want to have them away from the EU territory. I don't know, but this is maybe, it might be a possibility. Maybe it is a little bit cynical, but this was the reasoning also behind other setup, you know, to keep people away of the EU territories. So this is my first point. My second point on hubs, this is, yes, about monitoring a little bit. I think when it comes to monitoring, if we don't know the intended function, it will be difficult to set up a good monitoring mechanism. And the first line for monitoring will definitely be the national courts, because they have played a central role for current experiences, I would say, in responding to legal uncertainty and rights violations. So then also, I think this was my last point on hubs. Yeah, okay, thanks.
Thank you, Virginie. Then over to you, Izabella.
Thanks, Alberto. So my very final thoughts are going to pick up Richard's remark, a question about whether the proposal really helps streamlining the procedure. And I'm going to also look at what you mentioned, Article 7.4, whether the written decision can be issued without specifying the country of destination. Well, how can you issue a return destination, meaning how can you assess the risk of refoulement without explaining where the person will be returned? So I would say it goes a bit in the same direction what I mentioned with my introductory thoughts. So there is a huge emphasis on issuing return decision, even without knowing where the person could be returned, even without checking the refoulement, the principle of non-refoulement before, for the sake of streamlining, for the sake of doing something. And then, so what comes after? So first of all, remedies should come after, because if the non-refoulement was not assessed before, it should be assessed after. And of course, there is that new provision that I referred to, which is very positive, but it means there is even more need for adequate remedies and the procedures after, and it also costs. And the second thing, again, implementation. So how can you implement decisions which are already issued at all costs and may not have checked all the non-return grants? So again, it may lead potentially to a return gaps or return rate gaps, which actually the proposal is trying to remedy. Thank you so much.
Yeah, I would say that our reflection is that there's an increasing reference in the international human rights framework to a lot of the guarantees. You know, this I mentioned children and non-detention, It's from 2017. We didn't have that before 2017. So we see that on the global and the international human rights framework, we have an increasing convergence on what should and shouldn't be acceptable concerning return, concerning detention. But we don't see that translated. We see this gap in between this convergence kind of on the one hand on the human rights framework acknowledgements and how that's translated into practice. We also see a gap in terms of what's happening on the ground, how practitioners, how cities see this, how social workers, how researchers see this. This project that we're part of more interviewed judges, people working in detention centers, police officers, and surprisingly, many of those institutional professionals also felt that they should not be tasked with doing immigration enforcement, that their resources in their professions were actually questionably implied in kind of doing these tasks. So we also see there's a growing gap in between the reality and the practice on the ground and how it's translated into the policy framework. So I would maybe just end it by saying there's also an openness for discussion. I think there's a lot of objective discussions that can be had about many of these different elements, but they need to be objectively discussed. We don't see member states talking about all of these types of residence permits that they have. Do they talk about how to really do alternatives to detention in a very progressive way? So where is that space? How is that going to be discussed as this goes forward? As the Parliament looks at it, as the Council looks at it. So I think the invitation is there.
Thank you, Michele. And with this, I want to thank our speakers, first of all, for having joined us and for having stayed for sensibly longer than initially anticipated. Our participants, both in the room and online, and also responding to this call by Michele. Clearly, there is a lot of work ahead of all of us. And with Egmont, EPC will certainly continue following this file, and there will be further opportunities to continue discussing with all those who participated in this event the future of the Commission's proposal. Thank you all and have a good afternoon.